that John and Jane, every time they need funds to help raise Jesse for their friends, have to go to these people and ask for funds. Now that may be a good idea, it may not be a good idea. What if the people are family members who are hostile to John and Jane having control of that person, of Jesse? So if you're gonna have somebody be the guardian of your children, you've gotta think through how are your assets that you're leaving for them, and hopefully you are leaving assets for them to raise that child. How are those assets going to be governed, and who's going to do that as well? I think in most cases, if you're gonna trust someone with your child, you might as well trust them with your money too, right? That would be my guess in most cases. Some people don't feel that way, they wanna divide those up into two different camps, and that can be difficult. And if you divide it up that way, what might end up happening is the people that you've appointed a legal guardian of the person may decline to be the guardian, right? They may just say, "Nah, that's not gonna work." Okay? Questions, comments about that? Children are the ones, this is where it really gets tough. And this is where it makes a lot of sense to hire somebody who knows what they're doing. And Cam, to answer your question, I don't think I fully answered it when you said, should you get a second opinion, or what should you do when you get the draft documents? I think if you're dealing with really good, competent attorneys, you go ahead and get the documents signed, but then at some point in time, it would not hurt to take it to another competent attorney and say, what do you think about these documents? Yeah, I wouldn't necessarily do it right away, but maybe 2, 3, or 4 years down the road, it's something that, especially if you've had another kid or two, you might want to take it in there and say, okay, review these for me and tell me what you think. It's worth a couple $100 for the year. Third example, Jack and Pam are both 50. It's a second marriage for both. And they've been married 1 year. Jack's first wife, Jill, died at age 45. Pam's first husband, Billy, was in prison for murder. Pam divorced him 10 years ago. Jack and his first wife, Jill, had twin children, Tracy and Betty, and they are both 25 years old. Pam and Billy had one child, Billy Jr., who is 30 and struggles with drug addiction. Okay? I actually have clients that are almost exact identical to this one. Jack has $1 million of life insurance he purchased before he married Pam, and Pam is the beneficiary. Jack and Pam own their $350,000 home, joint tenants with rights of survivorship, and there's no mortgage on it. Jack has joint bank accounts with Pam totaling about $100,000. Jack has no will. Jack dies of a heart attack at age 51, and then a few months later, Pam dies of a stroke. Tragic, huh? Now, what happens to their property? Yes?
Because of the deed, they have no will, they have no way of carrying out the life insurance or anything. It's supposed to be carried out. There's nothing that's supposed to help.
That's a good guess, and it's almost right. That's right. Yes?
I had a Pam's doesn't have a will, so I presume we would follow Pam's will.
Let's say in this instance, the Pam doesn't have a will.
Trick question.
It actually is, in either case, it won't matter. We'll see in a second, probably. It'll matter a little bit, not a lot. So who ends up with all the assets?
Billy.
Yeah. Right. Yeah. Yeah, so who gets left out? Tracy and Betty are completely left out. Nothing goes to them. Because everything goes to Pam, and then Pam dies intestate, and the intestate laws say it goes to her children, not her stepchildren, her children. So you would not believe how much this happens, how this happens, stuff just like this. So this is a situation where even if Pam would have had a will, that in itself would not necessarily protect Tracy and Betty, because after Jack dies, Pam could change her will, right? So this is one of those situations where when you have children from previous marriages, this gets really into the next topic that we would be talking about, which is trust. Because you can create a situation where money goes into trusts, and this trust then would pay income to Pam for her life, and then when Pam died, it would go to Tracy and Betty. So it all can be done, it can be created. There's a lot of complexity involved in all this stuff. But basically what you want to do is when you sit down with an attorney, you want to have an outline of, this is what I want. These are our goals, this is what we want to happen. If both of us die, this is what we want to happen. This is who we want to raise our kids. This is who we want to have control of their property for their benefit. All those type of things are important. So if you basically walk in with an idea, this is what our goals are and this is what we're trying to accomplish, it will make it much easier to get these things done. The more assets you have, the more marriages you have, the more children you have, the more generations are involved, the more difficult it is. All right, questions? Yes. Well, okay, so if you went around calling a bunch of law offices, you could probably find an attorney's office that'd be willing to do will for you and powers of attorneys for healthcare and finance for, I don't know, maybe $350. Probably more likely to see it around $500. You can, if you want to get somebody who's really, really good, that really knows their stuff, and you want to make sure this thing's tied up and really done right, $750 to $1,000 maybe. That's per person. You can get online and you can go on, Nolo, or you can do LegalZoom, you can do places like that. The only thing I'd tell you is if you do something like that, and get the documents signed and do all those type of things, you probably ought to take it into a law office and have them look at it for you. They won't like it because you're showing them something that they feel like is their competitor, but they'll do it, and they'll tell you if it's been done correctly to make your goals. It's going to cost you a little bit extra, but I think if you go into especially if you have children involved, I think it's dangerous to go LegalZoom. I really do. That might be fine. And think about this. So as long as you both have, if you have all your property in joint name, you have your beneficiary designations and your life insurance and your 401ks and your IRAs all taken care of. You have joint bank accounts, and one of you dies, there's not going to be much of a problem, right? Because all the assets are going to go, not from a financial point of view. Yeah, from a financial point of view. So it's all the assets are going to go to your spouse. There's not going to be a probate estate. There's not going to be issues. The child is being taken care of by the spouse. It's when two people die in succession, or when one person dies and then through the grief that's out there, you don't change your wills, to make, because after your spouse dies, you need to change your will to reflect the new reality that you have. A lot of times grief just doesn't allow people to do that. It takes a long time to recover from a spouse dying. And so a lot of those things are just things like that you just have to think about it. And yes?
So obviously, for Jess and I, we can ask people questions all the time. But for everyone else, is there anything that you're going to give us at the end that is maybe a checklist or something like before we go in to see a lawyer? These are some things that we should put together to save us time and money, so that when we get there, we're not having to go through all that with the lawyer. I don't know if that makes sense, but
Yeah.
are there basics that we can get in line before we go to the lawyer, so that when we go there, we're prepared?
There's a lot of those on the internet. There's really tons of them that you can get. And checklists are really good. The narrative of what you're trying to accomplish is really important. When you don't have a lot of complexity and everything, that's the important thing. And it's much easier and simpler to accomplish. The thing that gets people messed up the most, really at your stage of life mostly, if you're not talking about both of you dying at the same time with a child. It's the power of attorney is the one that can really get messed up. So you probably want to get that one done for sure. And since you're going to go into a law office to do that, that's one of those ones in LegalZoom. You can get it done in LegalZoom. I haven't looked at LegalZoom for several years, so I don't know if they really updated their powers of attorneys to include social media and things like that. But believe me, 90% of attorneys you walk into their office, they'll never even bring it up.
They won't bring it up?
They won't.
Even
No.
now?
There's no statutory part in the state of Illinois that deals with it. They're talking about it right now at the Illinois Bar Association. And a lot of the states are talking about it, but only maybe a handful of states have actually enacted statutes that they put it on their forms now where it actually is taken care of. So what I did when I was in Connecticut last year, I grabbed the statutes from one of my attorneys I was visiting with out there. I brought it back to Springfield and gave it to some of the attorneys there, and I said, this is what you need to put in these documents. You know, something like this. So figure it out. Let's just start adding these things into our documents for the clients, because we need this, right? So that's, it's just something that none of this is perfect. It's not going to work out perfect, but taking some action and thoughtful action is better than no action. Yes?
Just from a little research I did, it talked about when you do a will, you have to basically testify that you're of sound mind. So if you just lost a spouse, at what point would you be able to re-sign a lease?
Well, sound mind simply means that you know who your beneficiaries are, and you know you're signing a will, and you understand what that means. That's what a sound mind means. So a person who is grieving doesn't necessarily mean they're not of sound mind.
Okay.
Although, believe me, we deal with that a lot, and there are people that we talk to whose spouse died a month or two before that, and we'll have total conversations that they won't remember in a month or two. It's just grief does terrible things to people. It's really
Okay.
Okay, anything else? A lot of information on the internet. Like I said, if you want to see the Illinois statutory short form power of attorney, it's on the internet. I would not try to fill it out myself and do that. It's too complicated. But now that you have a little bit of education, you know what you ought to be asking attorneys, you know the kind of things to look for, maybe some of the things that you need to take care of quickly under some of your documents. But it's worth getting a little bit of education and continuing to educate yourself little by little over time. All right? All right, thanks a lot.